Hi everyone, thank you for joining today's webinar presentation, Overcoming Examiner Variability in the Patent Office. I'm Gail Martin, Associate Marketing Manager at LexisNexis IP, and I want to cover a couple of things before we get started. Please feel free to submit questions during the conference by using the Q&A feature on your panel. You can download a copy of the slides from the panel itself. These and a link to the recording from today's presentation will also be sent to you. Now I'd like to introduce today's presenters. Quinn. Jean is the founder of IPWatchdog.com, a patent attorney, law professor, and leading commentator on patent law and innovation policy. Jean was recently named one of the world's leading IP strategists by IAM for the second consecutive year. Joining with Jean are Todd Dickinson and Megan McLoughlin. Todd Dickinson is a senior partner at Polsinelli. As the former Undersecretary of Commerce for Intellectual Property and Director of the U.S. Patent and Trademark Office, Todd possesses an in-depth knowledge of the USPTO and its practices, as well as an uncommon perspective on all facets of U.S. and international IP practice and policy. During his 35-year career, Todd has also been Chief IP Counsel for 2 Fortune 50 companies. More recently, Todd served as the Executive Director of the American Intellectual Property Law Association, an association of more than 15,000 members and one of the world's leading policy and advocacy organizations in the field of intellectual property. He played a key role in the drafting and passage of the America Invents Act and the subsequent PTO rules, including all aspects of post-grant review. Finally is Megan McLoughlin. Megan is the Product Director for LexisNexis Patent Advisor, a suite of patent prosecution management tools. Previously, she worked as a patent attorney at the law firm of Nutter, McLoughlin & Fish, primarily drafting and prosecuting patent applications. Thank you again, everyone, for attending today's presentation. And with that, I will turn it to you, Jean.
Thanks a lot, Gail, and thank you all for being here with us today to talk about this issue. We have a very interesting presentation in store for you today that is brought to us really because of the big data world that we live in. I think that we've all probably understood for probably the duration of our careers that there has been variability from one examiner to another at the patent office throughout our careers, and there's a variety of different reasons for that. We're not going to go into necessarily making any accusations about that today. We're just going to observe that exists, and we're going to try and talk about some of the reasons that might happen and what you might do about that while you're trying to represent your clients. But some of the statistics are eye-opening, and when you see them, I think what they do offer is some real strategic opportunities to try and figure out creative ways to navigate through the patent office on behalf of your clients if you're willing to engage in more than just file and wait kind of advocacy. So we have Todd here with us today, who is going to provide us some kind of commentary, hopefully, about how the patent office works and what is really possible and achievable at the patent office, and maybe what goes on behind the scenes at the patent office to give us an idea of what we see from the outside and make some sense of that. And Megan is going to lead us off with some statistics, kind of set the stage for the discussion before we get into the recommendations on the back end. But before we get into the presentation, what I'd like to do is bring the panelists in right now. And Megan, since you're the author of the slides that give us the statistics, we'll start with you. And Todd, I'll ask you the same question. What do you think is the most important thing for people to keep in mind as we approach the topic of examiner variability?
Yep. Thanks, Jean, and thank you everyone for taking the time to hear us out today. What I want people to walk away with is the notion that the data that I'm presenting today is really an opportunity for patent practitioners. A lot of it sounds negative. We're talking about outcome variability, which in an ideal world wouldn't exist, but we don't live in an ideal world. And I actually think that this outcome variability creates an opportunity to put some lawyering back into patent lawyering and allow us to be better advocates for our clients.
Okay, thanks, Megan. Todd, your preliminary thoughts on the matter.
Well, I think there are a number of variables that will go into this. It'll probably become apparent, and many of them I think are probably known to your audience. But certainly things like the experience level of individual examiners, the technical background, and frankly the technical complexity of various technologies. Some are simpler than others. Some are more cutting edge than others, and they're still developing. Another thing that examiners have to wrestle with all the time is a relatively constantly changing legal environment. We're about to get a new set of 101 guidelines, for example, that are presumably a reflection of the interpretation of the recent Supreme Court case law. And so it's not surprising to me that there is some variability at the office, and we'll see it in these slides. But I certainly want to start off by commending the office, because I'm still a great believer after 20 years away of how great a job the examiners do day to day, particularly under the kind of limitations that we'll talk about.
Yeah, and my 2 cents here, just to begin, and because we have a question that was sent to us before we even started by somebody who is going to listen to this webinar next week and couldn't join us here today in our audience, but about a situation where they're dealing with an examiner who is not allowing a case, and what do they do about that? And it's a situation where there seems to be maybe a history of this particular examiner not allowing cases and what have you. And if there are situations at the office where there seems to be some kind of procedural irregularities like that, I think what you need to do is you need to reach out to the office, to the commissioner, for example, and we'll talk about this later on. And I say this in many of my webinars, and I'll say it again here right now, and I'll say it again later on, is the commissioner, Drew Hirschfeld, tells me every time I speak with him that if something is you encounter something in a case that you think the office needs to know about, he wants to know about it. So please reach out to talk to him, and he encourages me to tell patent attorneys to do that. And I talk to him every time I see him. I say, has any patent attorneys called you and told you that, Gene Quinn told me to call you? And the answer is always no. And he does want to know. So the office, to Todd's point, they're trying to do a really good job. Most of the examiners are doing a very good job. And we are participants in this process. So if you see something, say something, I think is what I want to say to just start us off. So Megan, I'll let you drive the slides since you're the master creator here. And just so you all know, if you want to download these slides right now, you can do that on the GoToWebinar control panel. But this presentation and the slides will be sent to everybody after the conclusion of the program.
Yep. Thanks, Gene. So I want to start off by setting the stage and talking about a little bit about what this variability looks like and how we on the Patent Advisor team measure the variability, because I think that's also very important to set the stage. So like Gene said, anybody who's practiced in this area knows that there's variability in examiner behavior, right? Some examiners grant patents quickly and some examiners grant patents slowly. And I also want to say that I totally agree with Todd. None of this data is meant to be an indictment of the patent office. We understand that there's a million variables that they have to deal with. I have 2 kids and I can't get them to do what I want. So I can't imagine managing 10,000 people and trying to get them to act in a perfectly uniform manner with all these variables going on. But nonetheless, there is some significant variability. And the data that I'm showing right now, this actually comes from a paper that was published back in 2012, and that really motivated the creation of products like ours, like Patent Advisor, to illuminate some of this variability. So this paper was written by a law professor named Shine Tu, and what he discovered is that about 10% of the entire examiner pool accounts for more than half of all the patents granted. So you have this one group of examiners who are turning out patents ridiculously quickly, more than 50 patents per year. But then on the flip side, you have 20% of examiners who are accounting for less than 1% of the patents that come out of the U.S. Patent Office. So really slow patent grantors, less than 5 patents per year. And you have everything in between. And like I said, I do want to take just a second to talk about how we measure fast and slow granting. So previously in the industry, the prevailing metric has been allowance rate. How many patents divided by patents plus abandonments, right? To determine, to kind of measure examiner behavior. And this has worked for many years, but it has some problems. It doesn't incorporate anything about the pending portfolio. So particularly for new examiners who just haven't had a chance to turn anything out yet, it's not a helpful metric. And it penalizes the examiner for abandonment. Sure, sometimes the abandonment is because the examiner was too difficult to work with, sure. But a lot of the time the abandonment is a business decision. Maybe the company just wanted to go a different direction. And so that's another problem with this metric. So we developed something that we call ETA. It sounds like estimated time of arrival, and you can think of it that way because it predicts the likely time and expense of getting a patent, but it actually stands for examiner time allocation. It's based solely on the examiner's own behavior because it measures what they're spending their day doing. Are they spending their day writing rejections or issuing allowances? And so at base, what ETA is the ratio of total office actions to total allowances. And it addresses a lot of the issues that we have with allowance rate. And just to give you an idea of how these two metrics vary, this chart shows allowance rate on the y-axis and our patent advisor ETA score on the x-axis. And you can see that for a single ETA score, there's tremendous variability in allowance rate, particularly in the median ranges. So we divided into ETA into 3 groups, green, red, and yellow. Green corresponds to fast patent granting examiners. These guys actually have a low ratio of office actions to allowances. And red corresponds to slower patent granting examiners, those that have a higher ratio of office actions to allowances. And you can see that particularly in the middle yellow range, there's huge variability in allowance rate for a particular ETA. And so we think that ETA is a much better predictor than allowance rate. And that's the score that we rely on. So what does the distribution of these ETA scores look like across the patent office? Because this is what we're really interested in talking about today. And if you look across the entire patent office, and I've excluded 2,900 for designs because what goes on there is so different from what you see with utility applications that I don't think it's really fair to include. But overall at the patent office, there's about an even number of green and red, about 25% of each, and then about 50% yellow. So it's kind of a nice distribution there. You can think of yellow as average, sure, green is fast, and red as slow. But there's significant variability when you start to drill down. So for example, at the tech center level, I took as an example the 2 most extreme tech centers, 2,800, the quote easiest for applicants, and 3,600, the most difficult for applicants. And you can see that 2,800 is overwhelmingly composed of green examiners, and 3,600 has the highest number of red examiners. Not surprising, right? Where you really start to see some variability, though, is when you drill down to tech center group and art unit levels. So before we came up with this metric, I think most people thought, and heck, even I thought, that your average art unit would look like a pretty bell curve, right? Average being the most examiners would be average, and then some would be fast and some would be slow. But in reality, there's just a lot of variability there. And my favorite example are these 2 adjacent groups, 2811 and 2812. As far as I can tell, and I am no expert in this area, but as far as I can tell, they cover similar technology. But 2811 has a perfectly even spread, 5 green, 5 yellow, 5 red, and 2812 is almost overwhelmingly green, very little red. So it does vary. And then again, just setting the stage, I want to talk a little bit about how we measure this distribution within a group of examiners. So the first way we measure it is just straight up ETA distribution, what I showed you on the previous page. How many of each type of examiner exist in a group? And this example shows 2811 in particular. So there's 5 green, 5 red, 5 yellow. But we also created a metric called the lottery map that I think is even more helpful for what we're going to talk about a little bit later on, for understanding what you can do about this variability. What this shows is your chance of getting a particular type of examiner if your application lands in that art unit. And you might think, well, if there's a perfectly even distribution, then there's going to be the same chance of ending up with each type of examiner. But that would be wrong, because by their very nature, green examiners have high docket turnover because they're moving through applications quickly. And so they have more open spaces. Whereas red examiners, by definition, aren't turning cases over as quickly, right? So they have slower docket turnover, which means they have fewer openings on their docket. So in this particular example, we determined that there is over a 50% chance of ending up with green and only about a 20% chance of ending up with red. So that's our lottery map and ETA distribution. That's what we use to measure how we're measuring the different types of examiners in a group. But what we really want to talk about today, and I'm so glad that Todd, you're on the line, because I think you can contribute much more than I can. I just look at the numbers, but I don't really know why they are that way. I want to talk about why this happens. And then after that, I hope we can talk about a little bit about how you as patent practitioners can work with this and maybe even use it to your advantage if you're a patent attorney or a patent agent, how you can use this information to better advocate for your clients. So did you want to jump in there, or do you want me to keep going?
No, well, let's go back to the last slide for just a minute and bring Todd in. And Todd, like when we were talking in the green room right before we went live, we were talking about the differences in technology and experience level, and one of the things that you did bring up, and because one of the reasons for this is examiner experience level, and can you maybe share what your thoughts were when we were talking about that moments ago?
Well, I think it's no surprise that the experience level of examiners will have an impact, particularly on the length of time that's devoted to a particular case. As a matter of fact, of course, it's built into the system. More junior examiners have more time allowed to them to examine and do the work in the case than more senior examiners who are expected to do them more quickly and more efficiently once they've got more practice. I think, as I said, it also depends somewhat on the technology. The same thing occurs there. If you have a very complicated software technology, you may have, 38 hours on average or something for the examination. Whereas if it's a simple technology or an older technology, it may be at the other end of the curve. So those are the two of the key variables that affect this. Other things that affect it, though, are individual examiners and how they work with cases. And if I could reiterate your earlier comment, and I may do it even one more time, if there are individual issues that come up, as opposed to this broader data, they should be taken up. Practitioners should not be wary of moving up the chain, if you will, or move up that ladder to try to get particular problems addressed. I wouldn't do it routinely, but if you're having a particular issue, moving up the ladder is a well-known and acceptable thing to do. And people say, well, I'm worried about retribution. You really shouldn't be. The office has things built in on that as well.
Can you elaborate maybe a little bit on that? Because, and I think and I hear it all the time, is there is still that fear of retribution, even though, I don't believe that there is retribution at the office. I know you don't believe it either, but that is something that patent attorneys do fear.
I understand that. It's human nature. But I also think that once you get things once you're assured of certain things, like it's in the right art unit and you got the right people generally on the examination, I've heard of very few actual instances. I'm sure there are war stories. I'm sure some of the folks on the phone could call in and tell us about them. But I've never heard of real actual incidents where there's been an examiner holding a grudge against a company or an applicant because they went up on a particular issue. Now it has to be a good issue. Moving it on up, complaining that it took 1 month more than you thought it should have taken is probably not going to get as good a response as having a technical issue or a legal issue. Or in some cases, there are certainly cases where you're going to find individual examiners who, for one reason or another, just are not responsive. There is examiner turnover, and so that'd be my advice.
Yeah, and it's my advice as well. And I just don't understand. If the stories are what I hear they are, practitioners really have to start doing that, because what I always hear is that I don't want to ruin the relationship I have with the examiner. But if the examiner has really told you that I haven't issued a patent since Alice and I'm not going to start with yours, there's really not much of a relationship to begin with. Now maybe what I'm being told isn't actually what is being said during the conversation in the interview. I don't know, but if those types of things are being said, those are precisely the types of things that the folks on the 10th floor in the Madison building want to know.
Right, because as was pointed out, this is now a 12,000 person organization, and managing it requires a lot of very sophisticated management techniques, and it requires a lot of very open communication in order to manage it well. But I also think, on the other side of the coin, applicants and their attorneys, maybe the attorneys in particular, need to have reasonable expectations. They have to manage their own expectations sometimes, and that's not always easy. And I think that's maybe when we get back to the data, you'll see if you have a less experienced examiner, it is just going to take a little longer, and you have to deal with that.
Right.
Yeah, actually, let's jump to that then.
Go ahead.
Yeah, let's jump to examiner experience, because this is one that really interests me, and we haven't broken this down to see what is the greatest source of variability, but this might be it. And then if I had to guess, I'd say it's examiner experience. And what this is showing right here is it's just a list of examiners in Art Unit 2811 with I'll call it extreme behavior. So the red ones and the green ones, and you can see that the examiners in the green group, if you look at their allowance rate, because it shows the total number of allowances over total dispositions, so you can kind of see which ones are more experienced, right? Higher total numbers mean more experience. You can see that the green examiners tend to have more experience. Like this top guy, 90% allowance rate, over 1,000 final dispositions in his or her career. And then on the flip side, the red examiners tend to have fewer total dispositions. In other words, less experience. So this is obviously a huge source of variability. Of course, you can find examples of experienced examiners who grant patents slowly. This is just one that I'm showing right here with this examiner A. He's got a high ETA in the red zone of 6.5, but has obviously been around since probably around 2003, so 15
Megan,
years.
Can you just break down for us, when we're looking at a 6.5 ETA, what does that mean? What does that mean to people? I think what it means is that this exam, like 6.5 well, maybe I should just let you explain it.
Yeah, so it means that they're issuing an allowance every 6.5 office action.
You may want to tell people what slide you're on, by the way, as we move through this.
Yeah. We're on the slide. It's causes of variability and experience. Yes. So for those of you who might be watching this at a later date, we're looking at causes of variability and experience.
Slide 13.
And so right now, slide 13. And so right now we're looking at an example of an experienced examiner who has a high ETA. And what that means is that they are issuing a lot of office actions before they're issuing an allowance. So the calculation is a little bit more complex than this, but in general, you can think of it as writing 6.5 office actions for every allowance that they issue. right? So in case number 1, they write an office action. In case number 2, they write an office action. Case number 3, they write an office action. Then they write another one in case number 1. They do this 6.5 times before they issue an allowance. And we would consider that to be on the slow granting side. So that's why we would call this person having a red ETA.
Yeah, and can you back up just one slide?
Mm-hmm.
So then when we would look at like examiner 4 here at the bottom, where this examiner's only has a total of 25 applications, it looks like that they've worked on, right?
Mm-hmm.
So
right.
so an ETA of 28 would not necessarily for that type of examiner be extraordinarily unusual, given that you would expect an examiner usually to issue a rejection in the first action almost universally.
Right. And so it's not uncommon to see incredibly high ETAs all the way up to 90. We cut it off at 99 just because at that point we feel like it's some reason. But there are examiners who have ETAs higher than 100, which means that they've written more than 100 office actions before they've issued one allowance. And this is common with new examiners. And I think the reason for this is that the size of their pending docket appears to be the same as the size of the pending docket of more experienced examiners. So it's just looking at, and there are exceptions to this, obviously, but it seems like all the examiners have like anywhere from like 50 to 100 pending cases, usually in the realm of 70 or 80. And that doesn't appear to vary based on their experience, which makes me think that when you like walk in the door at the patent office, you're immediately given a docket of like 60 or 70 cases. Is that accurate, Todd?
Yeah,
or no?
Let's bring Todd in on that. How does that actually work? Todd, do you know?
Well, examiners have to go through a relatively extensive training process to start with, and then they're assigned a docket. Eventually, they get up to roughly 100 a year, but they would probably start off somewhere in the range you're talking about.
Okay. So still pretty large though, right? Because what I'm thinking is if you show up at the USPTO, you finish your training and you're given a docket of, we'll say like 70 cases, that's big, right? Considering your level of experience. And it might take you a while just to get through those cases. And I guess the question is there an incentive to bring any of those cases to completion? Or is the incentive to do a first rejection in every single application first? Because that could take a while, and that could slow you down.
Well, I think the data clearly shows, it has shown over the years, that 85 to 90% of applications are going to have a first office action rejection. That's a function of how cases are drafted. It's historic. There used to be a cliche among attorneys that if you got a first office action allowance, you weren't claiming claiming broadly enough. Now, that's not a good thing these days when we try to focus more on 112 and careful claiming, but that's not unusual to have a first office action allowance rate like that.
Yeah, and it's also I have also been hearing examiners, at least former examiners who I encounter who have left the office and now are entering private practices as patent agents will tell me that a lot of times their supervisors have standing policies to issue first action rejections so that the force the applicant to make the record. Now we can say that maybe that shouldn't be the way, but in an era where you do have a PTAB and your quality is such an issue, I don't know that I see necessarily a problem with having a policy where if there are questions where the applicant does have some responsibility to make a record about what certain things mean. So it wouldn't be surprising to see an examiner who is inexperienced to have a very high ETA, but I would think it would be rather surprising outside of maybe a few extremely high-tech cutting-edge areas to see an experienced examiner have a high ETA.
You're right, and it is
because you're not with candor. Yeah, you're probably again the office tracks this data as well, and you're probably not likely to become an experienced examiner if you're not improving.
Yeah, well, let me ask you about that too, because I've wondered about that too, Todd. Because it's my understanding that with certain I wouldn't say younger, but newer examiners, if they don't make the grade, then they are during the probationary period they're let go. But I wonder, and then they start over with new trainees, and I wonder whether that's always the best way to do it, or whether enough time is put in to try and teach them how to make the grade, and whether we're just churning at the bottom end and speed is never improving at that bottom end because we're always dealing with younger examiners that don't get the experience they need.
Well, there are variables there, but I think by and large the office recognizes, like any well-managed organization, that if you make an investment in somebody at the beginning, you need to make sure that investment doesn't go south if you can help it. And it's simpler to train people than it is to go out and hire and recruit new people, frankly, and less time consuming and everything else. So I think that there is a concerted effort made to make sure the training is as thorough as possible. And if people are coming along at a slower rate, that they're given every assistance they can in order to come up to par. So there has to be, just again, human nature, the way organizations are managed, there will be people who drop out of the system for various reasons.
Right.
But I think there are an awful lot of efforts devoted to making sure maybe some would say too many, to staying in the system. These days in particular, in a booming economy, don't forget, it is very tough to recruit people. And the patent examining job is a great job, but there's a lot of great jobs out there at the moment, for good or bad. And so recruiting and maintaining at times like now is tough.
Yeah.
So I mean, I think this experience, this one cause of variability, I mean, it's to some extent it's just inevitable. And so maybe this is one of those things from a patent practitioner's perspective, you just need to know. You need to know so that you can change your prosecution strategy accordingly. And you also need to know if you're dealing with one of the exceptions to the rules, so I'm on the slide now of an example of an experienced but slow granting patent examiner. And then the next slide shows an example of an inexperienced but high patent granting examiner. This person, it looks like they've only been here for about 3 years, but they have an ETA of 1.7, which means that they're issuing an allowance for every 1.7 office actions on average, which is really fast for somebody who just started in this. I'm thinking this person had some experience somewhere else.
Yeah. Well,
can I ask you a question?
Go ahead.
Did you factor in things like continuations here? Because often either an applicant initiated one, but there's often the situation where you basically have an examiner initiated, the examiner suggests it to the applicant, and the applicant takes up that suggestion, which could affect this as well.
Yeah, absolutely. So in our system, you can use those filters to eliminate things like that. On these particular slides, I have not. But you'll still see things on all ends of the spectrum. And the general rules that I said will still hold true. But that is another question that I have. So I almost wonder, so the more experienced examiners, do they have more say over what applications they take up? And if so, are they more likely to take up applications that they know will go faster? Like, something that has, foreign priority, and, so there was another examiner already looked at it. Or do you think they take up a higher percentage of continuations? That's something I don't know.
I think the answer to the continuation is no, probably. I think the other issue is, with some limited exception, the patent prosecution highway would be an exception, I would guess. They try to avoid gaming the system in that sort of a way. We're talking about human beings, we're talking about a granular level, and particularly if a particular examiner gets well known for a subcategory of technology, they probably end up having a pretty good claim on those cases. But by and large, I think they're tried to be they make an effort to assign them on a fairly random basis within the class and subclass.
Okay. Yeah, I just wondered if that was one of the reasons that more experienced examiners tend to grant more quickly. But it sounds like probably not.
Well,
No,
there are incentives to moving cases along. You know, the count
Oh
system
yeah,
is
yeah.
an endless source of discussion, an endless source of tinkering. But there are many incentives to keep cases moving.
Yeah, and
Of course.
yeah, there are. I mean, so if a patent examiner philosophically is interested in issuing patents, there is an extreme incentive to issue patents because they can get to yes a whole lot quicker than they can to no if they're willing to work with the applicant, and the applicant is obviously willing to work with them.
Yeah.
Yes,
But
it is a two-way street.
yeah. So, but
Yeah.
I'd like to get to the last couple of slides, and then we got some questions I'd like to get to, because one of the things. Oh, what was on the previous slide here? Because I do think we
So I
wanted
just
to.
wanted to make clear. So actually, somebody posted, or Jean, you posted an article written by somebody about outcome variability pretty recently, saying some very similar things to what we're talking about today. And I was reading the comments, and a lot of people said, well, look, the variability is just caused by application merit. I mean, if you submit a patentable application, it's going to get patented, and if you don't, it's going to get rejected. And I mean, obviously, that's going to make a difference. But I included this slide just to prove that is definitely not the whole story. So what I did was I took a large Japanese chemical company, and I took all of their applications over the course of their history. And I divided them up into those applications that landed with green examiners and those that landed with red. And what I found is that of their applications that landed with green examiners, they had almost a 90% allowance rate. And of those that landed with red, their allowance rate was only about 40%. And the other statistics are all along the same line. You know, they had fewer office actions with green, more office actions with red, etc. You know, and this company, they're mostly filing in the same art units. So, technology is not a factor. It really is just the ETA distinction is what it is here. And this is true for any entity. I mean, really, like I've done this analysis for like 1,000 different entities, law firms, companies. You will always see this pattern. So application merit isn't the whole answer.
Yeah. So this gets us to the end here where we can talk about now what are we going to do? What do we do about this? Can an new examiner be signed? And I get this question a lot, and it's sadly the straightforward answer is no, not in the way that most people are thinking about it, where you're asking for, like, you might ask for a new judge in a litigation to be assigned for some reason. And while it's even extremely rare in litigation, there's just no precedent that I've seen or heard, and I don't know of any process even to do it at the patent office. I've never heard of an examiner being removed from a case at the patent office. So that kind of leaves you to the old-fashioned methods of filing continuations, filing applications.
Would be absent some very serious behavior issues. I mean, there are occasionally those kinds of things, but they're rare.
Right. Yeah. I mean, and we've seen a couple of those over the past couple of years where there has been a abusive examiner behavior that sort of bordered almost on it didn't get criminally prosecuted, but there's kind of high profile things. But
that's right. They get weeded out.
Yeah. So
what kind of extreme behavior are you talking about? Like, what can you give me an example of how extreme this has to be?
Well, the one that I was thinking that maybe Todd, you were thinking about the same one, was that examiner A who was making up the time that he was working and just wasn't working on applications.
Yep, that I've heard of examples where they have a conflict of interest which wasn't disclosed, for example.
Yeah, there was another examiner let go for that particular reason as well over the last couple of years.
So pretty extreme ethical stuff.
Yeah.
Ethical violations.
Yeah. Either ethical or, in the case of making up time work, that the Alexandria DA did not pursue criminal charges, but that very easily could have been a criminal referral. So absent those kinds of things, you're not going to get an examiner removed, and you're not even in those cases really going to get the examiner removed. What happens is the examiner is removed from the office. They're taken out of the office, or at least segregated pending employment disciplinary procedures. So that leaves you to these, the old-fashioned methods that we are.
Well, Gene, let me stop. Can I stop for a second?
Sure,
And there's
sure.
the office. There's a very good reason why why the office is not inclined to do this sort of thing. Because if it was known that it was available, you'd have no end of people trying to game the system and find their favorite examiner, and you leave opportunities for all sorts of inappropriate behaviors if you're able to work it that way. I think it's the same reason we have uniformity of technology in the system, is so we don't start favoring one thing over another, one person over another, and I think it would be a bad system if you were able to somehow manipulate which examiner, which argument you end up with.
Right.
But there are, as you point out, there are ways. There's certain ways to try to, and you'll get into them right now, to talk about
which
other things.
is what I'm going to. Okay, now having Todd say that, now I'm going to tell you how to do it. But you can't pick your examiner, and there's no guarantees that the examiner you're dealing with is going to be off the case. I mean, one of the ways that you might, if you have some kind of suspicion that you might be going to go to an unfavorable art unit that has many red examiners over green examiners, then maybe what you might want to do is intentionally file an application that has multiple inventions in there and file claims to those multiple inventions and provoke a restriction. I mean, not that that's the world's greatest strategy, but it is a strategy. Now, if we go to the next slide, we have a couple more strategies that are probably, better. One, this got added at the last minute and people are probably going to laugh, but we've also had some questions about how do you move up the ladder. One of the first ways is the ombudsman. Now, the ombudsman is not going to help you with anything that is substantive, but if what you're dealing with is an examiner who is simply taking forever to issue actions compared to other examiners in the art unit, or an examiner who just is not issuing anything, maybe at least the call to the ombudsman might be worthwhile. Now, people tell me I called the ombudsman and it didn't help. Well, it was a phone call. It was an email, or it doesn't strike me as a phone call or email is a tremendous waste of time. That is one way to start. And I found the ombudsman program to be helpful within a limited slice, albeit, but that's one way. The next way is, you can talk to the SPE. Maybe sometimes you think the SPE is the problem. Well, maybe you can talk to the tech group director. But we have somebody gave me a comment here that they have called Drew Hirschfeld's office, the commissioner's office, and while they didn't talk to him, they found his staff extremely helpful and extremely interested in listening to what this person had to say. So that's how you walk up the ladder, I think, in a responsible way. And not that they can fix every problem, but like they continue to say, if they don't know of these problems, they can't possibly fix them. The other two, I think, are ways that are really, if you want to do and your client wants to play ball, you have to start talking to them about this. One is prioritized examination, the so-called track one, where you're going to get an answer within a year, and frequently you're going to get an answer within 6 months. And it seems as if the patent office, the allowance rate in those track one cases is higher. They seem to put examiners on those cases that are more experienced examiners that can handle the faster pace of prosecution. So yes, you have to pay more, but if you're going to otherwise languish for 5, 6, 7, 8 years, and you're dealing with an area where you're going to be getting likely a red examiner that's going to take forever to get to yes, and maybe ultimately your client is going to have to abandon because the time frame has passed the technology by, prioritized examination is a choice that you can make and get to yes or an answer very quickly. And patent prosecution highway is another one.
But wait a second, Gene. Hey, Gene.
Yep,
also, don't forget there are other ways to get the application prioritized besides paying the fee. You could fall into one of the technologies which they've granted exceptions to. You could be over 65 as an applicant. I think it's 65 still.
And there's a few others. Like if
Yeah.
it combats terrorism or it deals with the environment, or there's a handful of them that are even you can prioritize without a fee.
Yes. I'm still intrigued by the fact that we have a very low rate of prioritization requests, fast track requests. It's on the order of 5% or something, which is intriguing because, as this whole presentation is devoted to, pendency is a big issue for applicants, and yet there are means to deal with pendency that don't have anything to do with who the specific examiner is necessarily, which are not taken advantage of.
I
Do you have any thoughts on why
completely
that is?
agree.
Why
I
do you
don't
think that
know.
is?
I couldn't tell you
People
because
just don't know.
no, I don't know.
Some technologies favor longer pendencies, to be candid about it.
Right. In the biotech area, it makes sense. In the pharma area, it might make sense also because, you're filing at such an early stage, you don't know whether this is going to be something that's going to ultimately wind up being useful. But in other areas, it just doesn't make any sense. I talked to every client I've ever had since it's been available about it, and they all always seem to like it right up until it's time to file, and then all of a sudden they don't want it. And then somewhere along the way, they start to complain that they can't get a patent, but you wind up, if you look at the pendency and the time and the cost of the time delays and how many RCEs you might need to file and everything, it is way cheaper to file prioritize, even if you have to pay for it. But there's, if your inventor is 65 or older, or they're ill, or your invention relates in any way to the environment or in any way to fighting terrorism, and or in I think there's another one. I think if it's in any way, fighting AIDS or something like that, you can accelerate under track 1 for free. And I don't get why people don't prioritize, because you get the answer much quicker. You get a higher allowance rate. But then the same
Kate
is also
Gaudry from Kilpatrick has a really good paper on track 1 and allowance rate. It does result in a higher allowance rate.
Yeah, and the same is also true with patent prosecution highway. If you're going to get into an art unit that's going to take a long period of time, and or even if you have a lot of examiners that are going to issue patents, just going to take a while to get to them. File in the U.S., get your foreign filing license. Don't go through the Byzantine process to file and get the foreign filing. Just file in the U.S., get your foreign filing license, then file in Canada. Do the Toronto Pronto, and then file a PPH in the U.S., because it's my understanding that those are also likely different examiners doing the PPH examination when you move to the front of the line.
That's generally correct, unless it's a very, very specific technology.
So
I'll give you an example there. A very prominent, I've heard him give speeches about it, so it's not a big secret, but a very prominent personal care and food company experimented with, took one of their food lines, I believe it was orange juice patents, and put them all for a while through Toronto Pronto, and they were getting U.S. patents issued out of the printer within 8 months.
Yeah, that's Toronto Pronto. I mean, and you're going to get a Canadian patent out of it to boot. Now, so there are ways, and somebody has just said, well, cost of track 1 for a large entity is $4,000. Well, that's true if you don't have an inventor that's, 65. I mean, get an inventor who is 65, who adds something to some claim somewhere, and prioritize these things. I mean, there are creative ways to do this that can be done, that are within the rules, that are not going to cost you an arm and a leg, and are going to wind up being cheaper in the long run, even if you have to pay the fee. Now, granted, not all your clients are going to understand that it's going to be cheaper in the long run, even if they have to pay the fee. But if you're going to wind up with a situation where you're looking at the LexisNexis data and you're saying, look, we're going to, or maybe you wait, file the application, and then look up and see, wait a minute, we got an examiner that's red, and this person has only issued a few patents, and the patents that they issue take a very long time to get them to issue. What are our strategies? Lay it out in front of the clients. Well, we could Toronto Pronto this. We could file a continuation and track 1 it. We could just take our chances and file a continuation and write different claims and hope the continuation lands somewhere else. But I think just sitting around and waiting is not a useful strategy. Waiting and complaining when there are options to do something about it in a big data universe is I don't think is useful. I don't know. I mean, maybe I should stop preaching and I'll just throw it to you, Todd. And what thoughts on what we're talking about here, on what I just said? Or anything.
He agrees with you. He agrees with you completely.
I think maybe we might have lost him, or maybe he put himself on mute.
Oh, I'm sorry. I was on mute. I think we haven't talked about also talked about term adjustment. If it comes to the situation which falls within one of the categories or the situations at the office where they will give you additional term because the office took too long or took longer than their criteria for advancing the patent, you can get term adjustment, and you can get which would extend it out further. They do those calculations. There's a very elaborate algorithm for determining those calculations, but that's an opportunity or a possibility too. I think the other great thing about this data, this LexisNexis data, is not that it lets you try to figure out your examiner as an individual level, but it gives you, as I said earlier, the ability, maybe on the macro-ish level, on the art unit level or bigger than that, to manage your client's expectations if you're an attorney. It's just going to take that long if you're in a software art unit versus take that long in mousetraps. And I think applicants should be given a reasonable understanding of the kind of time we're talking about for this whole process. And this data, I think, gives you an opportunity to do that.
And I think it also, and then I think it also gives advocates an extra opportunity to give advice to their clients that they wouldn't be able to otherwise give. You know, if you know that there's a low business value case with a red examiner, and you're the attorney on that case, you want to circle back and talk to your client about that. And that's a whole new level of advocacy that I think this data can bring.
I got a couple points here from somebody who is in our audience. They say that in the CRISPR technology area, there is a growing trend to track one applications to issue to get to issue before they're published, and another free prioritization program is patents for patients. And I also know, actually, many of you might know the Bunch of Balloons invention, Josh Malone. All of his patents are track one, and he's a toy inventor, right? And maybe with some of those inventions, you have to track one of them because a lot of those kinds of inventions, and not his, because his is wildly successful in one of the most popular toys in the world. But with some of those inventions, the toys, they'll only have one holiday season. So if they're going to get knocked off, you're going to lose the whole invention. So track one is an incredibly important tool. Todd, I know you have
Go ahead.
I know you have a hard break at 1 o'clock, and we have a question here I want to get to you.
Sure.
To. It says, Todd, I have heard that examiners can be reprimanded for allowing cases with claims that are too broad. Is there no converse to examiners for rejecting applications that should legitimately be allowed? So are examiners reviewed for not allowing?
The first part of the question, I wouldn't say it's disciplined for allowing too broad claims. They are reviewed through a very elaborate process, and if they're not meeting certain quality standards, and that's a quality issue, then the examiner will be talked to, and then you move up the ladder of behaviors and fixes. On the other hand, whether they're too narrow or not, I think the same thing generally still applies. If the applicant is written as so narrow, are you saying when the examiner is trying to force a narrow claim, or when they're presented with a narrow claim that they aren't allowing? The latter, I guess.
What? Say that again.
Where they're presented with a narrow enough claim that it should be allowed, and they're not allowing it, is what you're saying.
Yeah. Are they reviewed for that?
Generally speaking, broadly, yes. We're talking about meeting the certain quality review, quality management data, quality management metrics that the office has laid down. And if they are not, then they are talked to or put on a PIP or that moves up the ladder, depending on how how egregious or frequent the behavior is.
Yeah. We have another question here about track one. Is it likely for an attorney not to recommend track one as it reduces the number of billable hours? I don't think that that's at all the case. I mean, I think in my practice, I've talked to many people about track one, and I've only had one client, I think, take it up and use it. So to the extent that attorneys are not advising clients about it, it's probably simply because we haven't had many people show any real interest in track one, shockingly, and I don't understand why that is. But and I don't know that it reduces a lot of the billable hours, because over the short period of time, it would actually be more money for the attorney over the 6-month period. But it would be less money over, like the several year period, probably. So, I mean, it gets people happy clients, right? Happy clients are good for attorneys.
I was going to say, yeah. So Patent Advisor, that tool is all about more efficient prosecution. And sometimes I get that feedback too, because in general, if you're using Patent Advisor the way that we intended it to be, you would get broader claims faster. And so it does, in theory, reduce billable hours. But what you gain is, like Jean said, you gain client loyalty. And clients, frankly, are expecting more for less all the time anyway. And this is a way for attorneys to deliver.
Yeah, and I
don't
don't
forget
know.
A lot of cases are being, for good or bad, maybe not so good, being written to flat fees, under flat fee arrangements at the moment as well, and that obviously becomes a factor. But if the flat fee is set such that for you then go ahead and recommend $4,000 as for a fast filing, probably not met with a lot of enthusiasm.
Yeah, that's true. And, I also think that, if you're using Patent Advisor data, I would think that you're going to get more work as an attorney, because what it does is it really should be eye-opening for the client and say, look at what we can do here. Now that we know this information, we can strategically navigate this application over here. And I don't think it's less work for attorneys. And I mean, maybe I'm naive, but I don't think that's a problem.
And remember that corporations. Go ahead, Todd.
No, go ahead.
Corporations are looking at this data too for their law firms. They're looking to see which law firms are getting quicker results, and so that's what your goal should be if you're a lawyer.
Right.
I think it also helps attorneys when they're trying to price these as well. If you can say this technology is going to be inherently longer and inherently more office action intensive, therefore this is what we have to charge you, but you'll have the data to back it up.
Absolutely.
Right.
So we're at the end, and Todd, I want to give you an opportunity to wrap up before you have to depart here, and I really appreciate you being with us. But your final thoughts on this matter of variability?
Well, let me make it broader than that. It's always better to have more data than less, I think, as long as you're able to digest it and use it. And I think what we've seen today is that you have the opportunity to do that with this data from LexisNexis. And as I have worked with it, I can think of a whole variety of ways that it can be useful. I don't think it's useful because the office tracks this stuff too, to start going after individual examiners or doing something that's not in the best interest of the office or yourself, frankly. But I don't think, hopefully people aren't going to be inclined to do that. I think they should use the data for the various purposes we talked about today, and it's good stuff. It's always better to have more data. Yeah,
that is, I think, the real takeaway here. If you have the data, you can really do an awful lot with it. And Megan, your final thoughts?
Yes, obviously, as the provider of this data, I could not agree more that you should have this data, shockingly. But really, I do think, Todd mentioned earlier that increasingly this industry is moving towards fixed fees. And even, so I haven't practiced for 4 years, but even when I left, it felt like the industry as a whole was moving towards a task-based commodity, respond to office action, file RCE. But when you have this kind of data, it really allows you to adapt and strategize and advocate for your clients in a whole new way. And so while obviously in an ideal world, we would want there to be no outcome variability, there's a silver lining to it. And it's that you can work with that and adapt your strategy based on what you see, or at a minimum, set expectations.
Well, and also, one point, if you're going to go up to the SPI or up to Drew Hirschfeld, the Commissioner for Patents, it helps you to have data to back up the points you're trying to make.
Absolutely, yeah, because they're going to not want to hear just the anecdote. They're going to want to see real information to back up your story. So, well, thank you both, and thank you all for spending a portion of your Thursday here with us. This is going to be our last webinar for 2019. So I wish all of you a very happy holiday season, happy new year, and we look forward to having you join us in 2019 for another great webinar series. So happy end of the year, and we will see you next year. Take care, everyone.
Thanks all.
Thanks.